Good afternoon, everybody, and welcome to this webinar this afternoon. My name is Anne Staunton from Rainbows Ireland, and I represent a group of 13 organisations and services that came together to access funding to be able to deliver training in relation to services and family support workers that are working directly with families who have separated. I represent, as I say, those 13 organisations. We undertook a training analysis, and one of the key needs that was identified during those training analysis was an understanding. Could we build an understanding and training and awareness training around the legal aid and the Irish legal system? So this is the third in a series of 4 integrated sessions. The first session gave an overview of the family and the courts and how the courts deal with family separation in general. And the last one dealt with the alternatives to the court and had a focus on mediation. And today's webinar deals very much with hearing the voice and assessing the best needs of a child. Also, a massive thank you to the Legal Aid Board, and in particular to Emily and Stephanie, who are conducting the presentation this afternoon. We wouldn't have been able to do these presentations and make them available without the support of the Legal Aid Board. So we hope you find this informative. I'm going to hand over now to Emily, and as I just to remind you, we will be giving you copies of the slides. We would also ask you, just before I hand over to Emily, to put any questions that you have in the Q&A as you go along. And between Emily and Stephanie, they will address those questions. They welcome those questions. And in fact, the wealth of experience that they bring to this will really inform the session. So please use the Q&A as we go along. And thank you. I'm going to hand over to Emily now.
Thank you, Anne. Yes, as Anne has very kindly introduced us, my name is Emily Sherlock and I'm a solicitor with the Legal Aid Board, and I manage Cavan Law Centre, and I'm going to be joined with my colleague Stephanie Coggins, who's the managing solicitor of Monaghan Law Centre. So I'm just going to share my screen. We've been asked today to talk to you about hearing the voice of the child and assessing the best interests of the child in both private law disputes and also public law matters. And we hope today that we will be able to, by the end of this session, you will be able to explain exactly what methods are involved in hearing the voice of a child in private law proceedings, and also to explain how a child's view may be heard and their best interest considered in a case involving the Child and Family Agency. And just before I go into my presentation, I just wanted to explain exactly what the difference is between public and private law proceedings, because I think it's important that that definition is known. So I've put up a definition here on the slide, and the definition of private law is that it governs the relationships between individuals, such as contracts and the law of obligations. And that's a bit wordy, but what it means is it governs the relationship between private couples. So that means that if a father or a mother is having difficulties following a separation in agreeing access or custody arrangements, or indeed matrimonial matters, then they may bring an application against the other parent. So it is an application and proceedings in relation to one parent as against another parent. Public law is the law governing the relationship between individuals, such as citizens and companies, and the state. So when we refer to public law proceedings, we mean proceedings that would have been issued and brought against a parent by the Child and Family Agency or Tusla, which are one and the same thing. And I suppose just for ease of reference, that we would refer to the Tusla as the Child and Family Agency, and when proceedings are issued, they're issued under the name of the Child and Family Agency. So when I'm referring to that, that's who we mean. So public law is basically where the Child and Family Agency or a state body are bringing proceedings against a private individual. So just by way of background, and in order to put the current legal position in context regarding the voice of the child, families in Ireland have diversified significantly over the last number of years, and over that time, the voice of the child has become essential to be heard in any cases involving issues of welfare regarding a child. The voice of the child has long been enshrined in family law proceedings since the introduction of the Judicial Separation and Family Law Act in 1989, and this act did provide for reports in guardianship cases to be procured. However, this provision was then put on a much more structured setting by the introduction of Section 47 of the Family Law Act of 1995. And since then, reports have been widely used in relation to the resolution of custody and access disputes. Even since the 90s, though, when that legislation was introduced, the Irish family has evolved further, and legislation has sought to keep up with the increasing diversity of the term family and take account of the changing nature of it in current Irish society. And that culminated in the Children and Family Relationships Act of 2015. And this legislation has been said to represent the most significant change in family law in a generation, and it does attempt to reflect the reality of the contemporary family in Ireland. So the 2015 Act now gives a statutory obligation to hear the voice of the child in proceedings concerning them. So that led us on to the 2012 constitutional reform. And I'm just going to go back to the slide previously, because that is a quote that was from an Australian family law judge that was made in 2009. And it really rings true. Children's proceedings are unlike any other civil litigation in this land. I mean, where else do you have the principal party about whom the action is and the orders will affect who doesn't have an audience? And that's so true. And it's long been the view of the courts that children should be heard in their proceedings. So hearing from a child early on in a family dispute can help focus the needs of the children and reduce both the intensity and the duration of a family conflict. And it may be empowering, improve child-parent relationships, but also the quality of any agreement that's ultimately reached in any proceedings. But at the same time, it is also important to know that hearing from a child needs to be managed in a way which best supports the child's welfare and best interests. So the United Nations Convention on the Rights of the Child gives children a right to express their views and to be given the opportunity to be heard in proceedings affecting them. And Ireland adopted the UN Convention, and this therefore gave rise to the referendum on the voice of the child, as the rights of the child, sorry. So the referendum on the rights of the child was heard in Ireland in October 2012, and following that referendum result, which had a really low turnout of only 33.5%, the 31st Amendment to the Constitution of Ireland was ratified. And Article 42A was inserted into the Constitution and provided that the state recognises and affirms the natural and imprescriptible rights of children, and shall, as far as practicable by its law, protect and vindicate those rights. This article then sets out a number of provisions dealing with child protection and care, including a requirement that the views of the child be ascertained and given due weight in matters of adoption, custody and guardianship, and where the state is bringing proceedings aimed at preventing the safety and welfare of any child from being prejudicially affected. So the first part of that is the private law, requirement the views of the child are ascertained in matters of adoption, custody and guardianship. And the second part, in proceedings where the state is bringing proceedings, is public law. So the amendment to the Constitution therefore ensures that the best interests and the voice of the child are now enshrined in Irish law. So that leads us on to how do we hear the voice of the child, and how do we hear the voice of the child in family law proceedings? And my part of the presentation is going to concentrate on the private law proceedings and how we hear the voice of the child in private law proceedings. And then Stephanie is going to talk about how we ascertain the views of the child and hear from the child in public law proceedings, which we would refer to as childcare proceedings. So now we've established that it's very important, and the importance of the right of the child to be heard is accepted. So a lot of work has been undertaken into ascertaining how best that can be done. And usually the way we would ascertain the views of the child and also welfare of the child would be to obtain a report on foot of Section 32 of the Children and Family Relationships Act, Section 47 of the Childcare Act, of the Family Law Act of 95. And there are another of other pieces of legislation and ways to obtain the voice of the child, which I'll go into in a few moments. So, as I've already explained, it was long established since 1995, when Section 47 was introduced, that it was important to hear the voice of the child. But the issue with Section 47 reports are that the costs of the report have to be borne by the parties, which can often mean that parties really just simply can't afford to obtain such a report. And also that part of the legislation was never enacted in the district court. So there was no provision for a Section 47 report to be obtained in the district court. So judges were often asked to adjudicate on allegations made by children against one parent and the other in private law proceedings, purely on the evidence of what the parents were saying. And obviously both parents would have a massively invested interest in the evidence they were put into the court. But the Children and Family Relationships Act of 2015 attempted to rectify those difficulties and made provision for 3 separate types of reports, which can be directed by both the district and the circuit court. So what is a Section 32 report? This is a report that provides for the power of a court to make directions for the purpose of procuring an expert report on any question affecting the welfare of the child, or to appoint an expert to determine and convey a child's views. And since the introduction of the Children and Family Relationships Act, the court are now under a positive obligation to take the child's views into account. So there's 2 separate types of Section 32 reports. There's a Section 32(1)A report and Section 32(1)B. Section 32(1)A is known as a welfare report, and Section 32(1)B is known as the Voice of the Child report. So a Section 32(1)A report will be directed if, for example, parents of a child can't decide on the access and custody arrangements for the child, or they wish the court to answer a specific question in relation to the welfare of the child, such as a relocation application, etc. In those circumstances, rather than just hearing from both the parents, the courts will often require a Section 32 report to be procured to enable an independent and qualified expert to look at the proceedings, to look at the question that the court's been asked to answer, and to make a report back to the court in relation to what they believe is in the best interests of the child. I currently have a case at the minute in relation to a relocation. And again, it's between a mother and a father. The mother wishes to relocate. The father doesn't want the child to relocate to another area. So what the court have done is they've directed that a report is prepared by an independent guardian ad litem in this case, who looked at the whole situation and will address the issues of any welfare concerns, etc., to the child, as well as hear from the voice of the child and report back to court in an independent, objective manner. And that report, along with the evidence of the parents, will be brought to the judge, and the judge will then hear all of the evidence and will make a decision on that. So that is an example of what a Section 32(1)A report would be used for. A Section 32(1)B report, however, is the power of a court to appoint an expert to determine and convey the child's views. And we would refer to that as a Voice of the Child report. So that is literally where an expert would be appointed to go out and speak to the child and ascertain their views. So the expert wouldn't necessarily be asked to give their opinion in relation to welfare concerns or welfare issues of the child, but purely what the child's views were and to report back to the court. So it's a way to ascertain what a child feels about something without being asked directly by a court, which would be inappropriate in almost every circumstance. Section 32 also provides for any report that's prepared in these circumstances to be given not only to the party to the proceedings, but can also be given to the child concerned if he or she is not a party. Depending on the age of the child, it's likely that the author to any report may have shared the contents largely with the child. However, although it's of course necessary for children to feel empowered in circumstances of family breakdown, it is important to tread very carefully in areas such as this, and not to overburden children with too much responsibility in already fraught family circumstances. And I'm going to talk to you in a little while in a bit more detail about whether or not those reports are indeed ever given to children or the parents. In addition, for Section 32 reports to be prepared, there's also certain qualifications that a reporter or an assessor would need to have. And again, I'm going to talk about those in a little bit more detail later on. The next type of report that I want to speak about today is a report on foot of Section 47 of the Family Law Act. So obviously you've heard me mention this a few times up to now, and this is slightly different to a Section 32 report. It's a bit more like the Section 32(1)A report in that it will mainly deal with welfare issues and concerns of the child. But these reports, it was previously only available in the circuit or high courts, but even since the introduction of the 2000 Family Relationships Act, although it's now available in the district court, it's rarely directed. It would usually be used in the circuit or the High Court. And personally, I've never recently had a Section 47 report directed in the District Court. We would always go for a Section 32 report. Also, a Section 32 report can be directed in the Circuit Court, but like that, I haven't ever come across that thus far. It's usually in the Circuit Court proceedings, which are usually matrimonial proceedings, that a Section 47 report would be prepared. Okay. Now, a Section 47 report, again, is usually to comment on the best interests of the child and welfare concerns of the child, as well as hearing the voice of the child. And it's usually carried out by a child psychologist, although guardian ad litem's or other family law assessors can also carry out these types of reports. It's a report that has to be ordered and directed by a judge, and its aim is to bring the wishes and views of the children to the attention of the court, as well as any welfare issues that need to be addressed or need to be decided upon by the court. And while preparing a Section 47 report, any assessor will meet with siblings, school teachers, child carers, and anyone else who's involved and is important in the child's life. They will then prepare a report with insight into the family structure and setup for the judge, but will also make professional recommendations on access and custody. So the expert, as I said, which is usually a child psychologist, is appointed to ensure that the views expressed by the child are fully placed before the court, and the court is required to facilitate the free expression of the child's views, and when testing the evidence, to ensure that those views are expressed not as a result of undue influence. So we'd often get queries in relation to parents that would feel that the other parent may be trying to alienate the children or place undue pressure or influence on a child to say one thing or another. And that is one of the reasons why an assessor, and usually with quite high qualifications, would be appointed in these types of reports to try and get through any allegations of that nature and to use their qualifications, their expertise, to see whether or not the child is saying what they're saying because of undue influence or alienation, or whether they are genuinely saying what they're saying because that's how they feel and that's what they want to happen. Again, an example of times when a Section 47 report may be directed are in occasions such as relocation, if children don't wish to attend for access and are refusing to attend for access, or if allegations have been made, such as sexual abuse allegations or other types of abuse, but maybe haven't been proven or haven't been referred to the Gardaí, that an assessor, such as a psychologist, would be employed by the court in order to prepare a report for the court to try and ascertain what their views are on that, and in their expert opinion, what is best for the child. And they can go as far as to make recommendations as to exactly what access should happen or which parent the child should live with. It is, however, just a piece of evidence before the court. So the judge doesn't have to make any orders in accordance with the report, but is there to listen and to use it as part of the evidence that they hear throughout any proceedings, as well as the evidence of each parent, and make a decision based on all of the evidence before them. But as I'll discuss in a few minutes as well, judges aren't qualified in the area of child protection or in the area of child psychology in order to ascertain who's telling the truth here. So it's really important that these experts are available so that they can report back to the court and the judge has an expert with whom they can rely on. The final report I'm going to talk about that's usually used in private law proceedings is a Section 20 report. And what a Section 20 report is it's quite different to a Section 32 or a Section 47 report. A Section 20 report is in accordance with Section 20 of the Child Care Act, and that provides that a court can ask the Child and Family Agency to carry out an investigation of the child's circumstances and report back to the court. And that is usually where there is significant welfare concerns of a child, where a judge may feel that the Child and Family Agency need to investigate further. The report should set out whether the CFA is making any applications in respect to the child and its reasons for so deciding, any service or assistance that it has provided to the family or intends to provide for the child and his or her family, and any other action that it has taken or proposes to take with respect to the child. So if the court is hearing a case and there are some very serious allegations in relation to child welfare or abuse, etc., or if the parents, which has happened in a case I've been involved in, are so intractable in their opinions and can't agree on absolutely anything to do with the child or children, to the point where it's having a detrimental effect on the children's emotional and possibly physical well-being, that a judge may say, you know, I'm not satisfied with the circumstances this child or children are living in, and direct a Section 20 report. And that almost invites in the Child and Family Agency to the family in order to investigate the family circumstances in both parents' houses and report back to the court as to whether they're seeing things have got to a level where they need to institute child protection proceedings, such as child protection register or supervision order, interim care order proceedings, or whether or not they think that just maybe some family support is required, etc. So that report is directed by the court. It's a court-ordered report, so the report goes back to the court after it's done, and it is paid for by the Child and Family Agency. It's not usually intended to be a holistic report, so it wouldn't comment on necessarily voice of the child or welfare concerns unless they are very serious. And it's usually quite a short report, and it's really to say whether or not the Child and Family Agency should become more involved in this family, or whether they think that's unnecessary at the time. So there is a growing trend to engage the services of a child views expert in contentious cases, especially where there are significant or entrenched access and custody issues. So the other issue is, especially prior to the 2015 Act, Section 20 reports were kind of being used by the district court as a Section 32 report, because parents, and obviously Stephanie and I working for the Legal Aid Board, wouldn't necessarily have the means to be able to fund a Section 32 or any other kind of expert involvement or reports to be for them. So what would often happen is a judge would say, well, listen, let's get an expert to have a look at this, but the only way to do that is the Section 20 report. Now, although that was done, the reality is it probably shouldn't really be, because that's not the point of a Section 20 report. But funding, and I'm sure we'll talk about this as the module goes on, funding is a massive issue and a massive obstacle to all parties and parents who are involved in these proceedings. And it's so important to be able to have those services available if necessary for parents who simply can't afford to do it otherwise. So the next way of ascertaining the voice of the child in private law proceedings is the judge. And again, this is not something that's dealt with very often, but especially where funding could be an issue, a judge may want to speak directly to a child. But that would also have to be borne in mind. What would also have to be borne in mind is the age and level of maturity of the child, and whether a child wishes to speak to a judge or not. I've been involved in many cases where children themselves have actually said that they want to speak to the judge themselves, and sometimes the judge will allow that to happen. But as I've said, hearing the voice of the child must directly be taken in the context of their age and level of maturity. And children's wishes and feelings, although are important, can often be trumped by their welfare. Speaking to children and hearing their voice can have a profound effect on a judge's decision when making any decisions in such proceedings. However, hearing a child's voice or their wishes and feelings must be taken into the context of their age and level of maturity. And I put a quote up here in relation to an English case, Re S, where a child said to a guardian ad litem, actually, in these circumstances, I want to leave my school. It's much more strict than it used to be. Me and my friends get picked on for things that never used to matter. And what the judge said in response to that said, well, if wishes and feelings rule, he would be walking away from school. But fortunately, they do not, and children of his age have to have their lives regulated by adult judgment. And again, judges aren't necessarily expertly trained in this area of speaking to children either. But judges have to be very careful when making decisions and including the voice of the child, that those decisions do reflect the child's best interests, because the overriding principle in all proceedings regarding children is that the paramount concern of the court is the best interest of the child. And it's not always the case that a child themselves knows what is in their best interest. And I think that has to be it's really important to remember that. In addition, there are no official guidelines for judges as to how best to speak with a child. And some judges really remain wary of interviewing children. And I have a quote from another judge who says, I've interviewed children on a number of occasions in regard to family matters, although it's not a practice that I would go into very often. I'm well aware of the danger that children may be coached in what they are to say to the court. And I think judges do feel that they necessarily have the expertise to be able to ascertain when a child is maybe being coached or not. And that's the reason why we would seek to obtain an expert to report back after speaking to a child. So listening to a child listening in an objective and child-centered manner is extremely difficult, and it's fraught with legal potholes. And just for an example as to how many judges may meet with a child or how many they wish to, a survey of Australian family law judges was taking place, and 86.4% said they had never met with a child for the purpose of hearing their views. So although the option is there, it's something that very rarely happens, and it is fraught with legal potholes. I was involved in a childcare case where a judge did speak to the children, and we're currently JRing the decision that was made in that proceedings. So, you know, it's something that judges have to be extremely careful about. So we're usually reviewing the decision that was made based on some of the evidence that was given. Yes, Stephanie, sorry.
Okay, Emily, just a question has come in. In domestic violence cases, if the judge decides to grant access, even though the children have said they don't want it, how can the mother enforce this? Or I presume the writer means how can the mother make sure access happens? Does she have to send them while waiting on an appeal? What would you say to that, Emily?
Well, if there's no stay on the order, so if an order is made and you're unhappy with it, you can apply to the court for a stay on the order. So it means the order doesn't take effect until an appeal has heard. But if judges often don't do that, so if that doesn't happen, then if there's orders there and the judge has heard the reasons why the mother is concerned about access and the concerns but still makes the order, then I suppose the advice is that the children have to go for access and that order needs to be adhered to. Obviously, if a mother has massive welfare concerns, then you'd be advising them to appeal, and you could also ask for a report to be prepared if one hasn't already in those circumstances. But if an order is made and the judge has heard the reasons why the mother has the concerns or there is domestic violence, then the reality is the order should be adhered to and the order should be respected. I think discussions can then take place though in relation to how access does take place and whether it's supervised, and does it take place in an access centre? Can a family member supervise, or can a family member bring the children to and from access to us to avoid any domestic violence engagement between the parties, I suppose? But it's very subjective as well, because I have a lot of domestic violence clients who have no difficulty with the children having access, because you know they're very sure that although that the perpetrator of the domestic violence is violent towards them, they feel that the children are safe with them. If they think the children are unsafe, then if you're breaching an order, then the reality is you're going to be brought back to court to enforce that order, and that goes into a whole other realm of contempt of court proceedings, or you know, if there's any penal notices attached where you could be sent to prison, I suppose, ultimately, but it rarely happens, and but transfer of custody is a big thing if one parent is refusing to abide by the terms of an access order. So it's quite subjective, and every case is very different. I don't know what you think, Stephanie, or if you've got a view.
Yeah, I'd have to agree. It's often look at the thing we hear the most as solicitors acting in access disputes is the child doesn't want to go, whether that be for a reason or for no reason, or for reason that the child understands or would be acceptable to a child, or for just that the parent doesn't accept, and that makes it extremely difficult. And that is why really the whole system of having a report and a structured report is such a good idea, because it means that the children are being asked their views in a controlled situation, I think, and they're able to give their answers in a controlled situation. And I do think the presence of an assessor also tends to even out some of the acrimony, maybe. Would that be a good way to put it?
Yeah.
And that's why they're such a good idea. Unfortunately, as Emily has said, they're not always available. But yes, I mean, in the end of the day, if there's a court order in being and the dispute has been heard and litigated on, and you're waiting, and sometimes you could be waiting months for an appeal, then yes, access has to take place, because the next thing is you have to advise your client, well, you're going to be done for breach of access, and that puts the whole thing onto a much more contentious level, really. So yeah. And
it's also the case that even if the case does go to appeal, it doesn't mean that the decision will be changed. Do you know, they may affirm the district court order to say that order has to remain in place. So I think a lot of it is about trying to open, you know, the dialogue and to discuss about what is the best way for access to take place here, because unfortunately, even parents that would have been maybe domestically violent, if they're not a risk to the children, access has to continue, and it's really difficult for the person who is a victim of the domestic violence, but if the children are safe.
I also think it's very interesting though. Again, I don't know what Emily thinks, but I know there's a lot more research coming to the fore about the impact of domestic violence directly on children. And I've read a bit about that, the research mostly going on in England, and research shows that children who experience domestic violence in the home, that it impacts it significantly negatively upon them, even if it's not them that haven't been the subject of the abuse. But well, I'm going to say yes, unfortunately, there are judges, and a lot of them, who form the view that access must take place, whether or which access is the right of the child. And if they hear a dispute and you know, they give a determination on it, they expect the orders to be adhered to, and that's an end to it. Now, I see just that person, sorry, another question came in, or the last person. In this case, the children said they don't want access and are scared of him during the Section 32 process. Well, yeah, then if obviously the judge then decided to make a certain decision, and appeal is the only option. And as Emily rightly points out, and you do have to remind your client of this, just because something's appealed doesn't necessarily mean the decision is going to be changed. And there's nothing you can do about that, because otherwise your client finds herself or himself in a much more difficult position, having breached an order. You know, so you can, I will say this much, and people used to do this a lot more before the lists got as busy as they are and as mad as they are. It is possible to go and look for an urgent hearing date if you think that something very considerably serious is taking place. Then you'd approach your court office for an urgent hearing date, and generally you will be facilitated, provided that can be confirmed.
And I think that one of the reasons for doing these modules, etc., and when in that person who said that the children are concerned about the Section 32 process, like it isn't a scary process, and that's the point of it. The whole point is that it's an expert that is used to working with children, that knows how to work with children, and to make it as easy as possible. But it's about information, and it's about being aware of what the process is, and that person will come and speak to you and speak to your family. And so just, I suppose, to be really open with the children about what the process is. And children don't want to pick one parent over another, very rarely, you know. But if they do, then the assessor will listen to them and they will report back to them, you know. And that's, so it's important that the parents, I suppose, are as aware of the process that will be taking place, to ensure that the children do feel safe and comfortable to be open and honest with the assessor, so their views can be properly heard and any welfare concerns can be addressed and brought before the court. And as Stephanie rightly said, if there is a really major concern that you know, you cannot abide by the terms of this order, then it's about putting it back before the court, not just ignoring it, because the reality is then you're the one who's going to be in trouble as the parent who's refusing access, you know.
Yeah, there was just that the last person has a final, which really is not appropriate for this session, because we are talking about the voice of the child, but in fairness to the person who's written in, would you agree that in most cases there's a perception that the court favours the mother in the majority of cases and the father is on the back foot from the very start? I'm really not getting into this, but I will say categorically that is not the case, categorically not. And as a matter of fact, more often times access is ordered in circumstances where we ourselves might have, you know, a doubt. But in any event, I want to keep the focus on the voice of the child, because that's what this is about. But thank you for the question. Now, Emily, I think that's all of the questions we have for the moment. Yeah, work away.
Perfect. Thank you, Stephanie. Okay, so that's just a short quote there, just from the judge, but I've gone through that. As the last thing, I suppose, in relation to obtaining the voice of the child is in relation to whether the child could be called as a witness. And there is provision for a child to be called as a witness in proceedings. However, I've never come across it, or maybe once only ever come across it. You know, a court is not a place for a child if at all possible. And although the provision is there, you have to be extremely careful in relation to whether or not a child will ever be called as a witness. And they would really have to weigh up the advantages that it would bring to the determination of the truth against any damage that it might do to the welfare of that or any other child. And I think that 99.9% of the time, it's not in the child's best interest to come to court and give any evidence. So it rarely happens. But listen, the provision is there, so it's just to let you know that is available.
Emily, there's just another question. And if access is granted by a judge and parent brings other family members to access, can the other parent stop access? You might like to answer that, Emily, but it's not strictly on point with what we're talking about, but go ahead.
Yeah, it's not really in relation to the voice of the child. I suppose, can they bring, listen, access is for the benefit of the children. And I think it's really important to remember that. Access isn't necessarily for the benefit of the parents. It is obviously in a child's best interest that where it is possible, they will have a relationship with both parents. But I think this is something that would need to be clarified when the matter is before the court, because the difficulty is then that there's access arrangements made, you turn up to Access, all the family come, the parent who is bringing the child to Access isn't happy with this, it causes a disagreement, it causes an argument. And I think this is where we would always really talk a lot about mediation, talk a lot about open communication. So to make sure that issues don't happen like that would affect the quality of the access with the child. But if the order is made for one parent and that the order says that access is to take place with the parent, then that really should be what is done, especially to begin with. But listen, if the resident parent is happy for access to take place with extended family members, and there's not a problem. So there's no yes or no answer to it. It depends what parents agree. It depends what parents and children are comfortable with. And it depends whether an order's been made that would affect that. Now, there is provision for family members other than parents to bring access applications, but again, that's going down a rabbit hole that isn't necessary for today's purposes and the voice of the child. So I don't know if that really answered your question, but it's difficult to give a yes or no answer to it. I suppose just to go back to that last question in relation to whether they bring family members with them, again, it's a really subjective question. You know, it really depends on the individual circumstances. And the difficulty with court orders, as there are other than agreements, is when you have a court order, you really have to stick to the exact terms of the order, unless there's provision to be a bit more flexible around it. If parents can agree matters, then there's a lot more scope for agreeing other things to happen. So bringing family members, it would be something that you would want to be agreed prior to the access taking place to make sure that it's not going to disrupt the children. But it's unlikely that the court would absolutely direct family members to be part of an order when they're not party to these proceedings, I suppose, is the strict answer. So another one there, Stephanie.
Oh, sorry, I keep forgetting to unmute myself. Yeah, I must say, in my experience, I have to say, people do all kinds of things in the context of access. They'll go to court, there'll be a bitterly determined dispute in relation to access, orders will be made, and then people will do things like bringing along other family members. That was never contemplated, and sometimes it can be very frustrating for us when we hear things like that, because you really long to wag your finger at somebody and say, would you ever cop on? And access is for the purpose of the child, and in circumstances where you know, even though we do have the facility for reports in these circumstances, the voice of the child isn't always, while the welfare of the child is to the forefront of the judge and the practitioners, the voice of the child isn't just always as immediately heard unless there's a report. And so you're also very conscious of the fact that while the adults are busy doing things that the adults want to do, that maybe that's not what the children want to do at all. So I would tend to be very blunt with my clients, and really I just think if there's an order made or an agreement entered into, then you should stick to that. Very good question in here, Emily. I'll just read it out to you. Are you going to speak about the voice of the child in the context of mediation?
Well, module 2 was about mediation. So although we do speak about mediation a lot, and obviously it will come into this, module 2 was all about mediation and the voice of the child, and bringing and hearing the voice of the child throughout mediation is a whole other subject. And you know, like Stephanie, there is a lot of research on that hearing the voice of the child in mediation is really important. And it's not something that I believe in practice happens a lot at the minute, but it's definitely something that I think mediators are massively open to. But hearing the voice of the child, and this is what we've been talking about so far, you have to be a real expert in order to hear the voice of the child and to hear the clear voice of the child, or the genuine voice of the child. It's not about sitting down, and that's what I spoke about there just with the judge. It's not about sitting down. I mean, if we listen to everything a child said and did it, they'd never eat broccoli again. Do you know, it's about being able to get away all of the extra bits and to say, okay, this is actually what this child really means. And that's just not an easy thing, and not everyone has the skill set to be able to do that. So yes, we're not going to talk about that. The mediation module will be on that, and I know it's going to be available for everyone who's signed up to the modules. But I suppose if you're asking for a personal opinion on it, I think it's important, but I think it has to be effectively managed, and it's not just as easy as sitting down and having a conversation with them.
I will add in my tuppence worth to that, which is that in general terms, people who attend mediation and who do so successfully, if I could put it like that, and who, you know, go through the process and come out with an agreement at the end, they tend to be very high functioning. And in general terms, mediation, in my experience, is not often the biggest problem when people go to mediation. You know, they go, now that's not to say that there shouldn't be, and again, this will form part of module 2, that there shouldn't be a mediator on site to help deal with. I'm a huge fan of mediation to help assist in disputes in relation to children, because very often there's a lot of heat and not much light around these disputes. And when mediation takes place, often all it requires is somebody to say, everybody just calm down now and let's talk about this rationally. No, behold, you have an agreement. But I suppose to the person who asked the question, mediation, when I think of mediation, and I shouldn't do this, but I do, I think of a mediation in the context of the overall family dispute, which would encompass property, money, and everything like that. And I always found that mediation, or that the issues relating to the children are not, in fact, the most contentious, because if they can go to mediation and if they're in a position to sit down in the same room with one another and talk to one another and arrive at an agreement, then in general terms, the issues surrounding the children are not intractable. But if you're also, caller or the writer is asking, I'm going to put words in your mouth now, are you asking, would we like to have an on-site mediator in the courthouses? Well, speaking for myself, I beg for it on an ongoing basis.
Continually.
Because we are not, as lawyers, we are not trained or not good at or not able to, or whatever way you want to put it, not about the business of resolving people's disputes with them directly. So I really feel that if there was more mediation in the courthouses of the country, I think things would work a bit. And I do know that's what the government want to do, but the cost of it, etc. Sorry, Emily, I cut right across.
No, you didn't at all. And I totally agree with you. And this is coming from someone that used to work in the UK and dealt with CAFCAS. And it's so important to have that service available, and hopefully with the new family courts bill we might get something there and thereabouts. And I don't want to go off track too much, but yeah, I completely agree with everything you've said, Stephanie. And in relation to child focused mediation, absolutely, I think it is a good thing. But the point is, I suppose, in relation to the Constitution, the amendment to the Constitution, hearing the voice of the child, actually only relates to proceedings. So it's in the family law context. And so I suppose that's maybe where we're falling down in this scenario, maybe with the mediation, etc. But as a best practice point of view, I think that absolutely hearing the voice of the child at every step of the way is important. You know, mediation through to proceedings.
Okay, one more question. If access is not working well due to continuing extreme hassle between parents, could they access mediation to support them to improve?
Yes. Mediation can be available at any stage of the proceedings, you know, right up to the final hearing. And I suppose a lot of the time when lawyers settle matters, you hear about them settling on the steps of the court. A lot of that is probably just getting the parties together and doing a bit of mediation into, okay, how can we sort this out? But from a formal mediation perspective, absolutely, it should be encouraged. And the law, I think the Act says that, Stephanie, correct me if I'm wrong, that mediation should be encouraged every step of the way.
It absolutely never too late. Yeah, and just I got a message there from Catherine just to say Model 2 looked at mediation. The recording and slides for all 4 modules will be circulated in June to all who registered for any of the modules in this series. The mediation issue it's a very, very important one, and it's one that we would champion and we would ask for all of the time. And it's all about the cost, you know, it comes back to the money in the end of the day. And it is a very valid question. Is the voice of the child heard in mediation? I you know, you've made me think, caller, really about that. I'll have to, that might be something we can think about again. But as I say, my experience with them would be that generally people who engage in successful mediations are quite, you know, the issues relating to the children aren't the worst ones.
Okay, so the obligations of the assessor. So I spoke again, and I said that I would mention this later on, as to, you know, who is an assessor and what do you need to be an assessor, and why are they the professionals or the experts for the court? And there wasn't any previous regulation in relation to what qualifications an assessor needed until the 2015 Act. And even at the 2015 Act, it was actually silent on the qualifications that an assessor needed to have. But since then, the Family Law Courts Development Committee have issued guidelines as to what obligations they place on an assessor who's going to meet the parents and prepare and the children, and to prepare a report for court. And they need to provide their CV. They have to have certain qualifications. So they have to have qualifications in relation to working with the child, etc. I don't have the details of exactly what they are, but I can get these if anyone wants them. They have to provide details to the parents as to the assessment, including particulars in relation to how they will engage with the children and what meetings will take place, who the assessor would wish to meet. Do they want to meet the one parent's new partner, or do they want to meet the school or the teachers, etc. Whether the meetings will be with parents and children, or whether just children on their own. How the assessor intends to communicate with the parties and relate matters to the parents and to the children, and what information and documentation that the parties should provide them, including information from third parties or institutions such as school or medical reports. And one of the major issues in relation to these reports is that they should be transparent. So there's no cloak and dagger. So both parties should know exactly what information is being given to the assessor, and the assessor should make sure that that's clear to both parties as to what they are getting. And they also can set out exactly how the voice of the child is going to be heard, because obviously that's the main reason for the report in a lot of ways, and in relation to hearing the voice of the child and welfare concerns. So they need to actually set out exactly how that's going to be heard. Another issue is in relation to the apportionment of the assessor's fees, and these guidelines say that the assessor's fees should be paid upfront, and that is because sometimes if one parent gets a report that they're not happy with or doesn't say necessarily what they wanted to say, then they would withhold fees. Assessors often won't release reports to families. And I just think it's important in the context of this meeting, when you're maybe supporting families who are going through this, they may not release reports to families until their fees have been paid. And that can obviously cause a massive delay for the proceedings, as a judge may not wish to hear a case until they have the benefit of the report. And if the report hasn't been released because fees haven't been paid, then that can cause significant delay. And the guidelines go on to state about how the assessment should be managed and other general requirements, such as how information is provided to them and whether they are abiding by the guidelines. Okay, and then just quickly, access to the contents of the expert report. Now, both section 47 and section 32, and I did mention this earlier on, provide that reports prepared under these relevant sections should be provided to the parties. And there has been considerable controversy that section 32.4 provides that a copy of a report under the section 32.1a may be provided in evidence to the proceeds. A copy of the report under section 1a may be provided in evidence to the proceeds and shall be given to the parties to the proceedings concerned, and if he or she is not a party to the proceedings, to the child concerned. However, in practice, the parties are not usually permitted to receive a copy of the report. Just to finish off, so I just have a couple of few more issues to raise, I suppose, and then I'll hand you over to Stephanie, and you'll be in her very capable hands for the rest of the module. But I don't know if there's any questions or anything, Stephanie, do we need to address before we get started again?
Well, yeah, let me just, there were three actually, but I can deal with one of them. What would the type of cost of employing an assessor be? I'll deal with that one if that's okay. And I've brought up a copy of one of the certificates on my laptop, so I'll be able to tell you exactly what the board will contribute. Then another person raises an interesting question. In your professional opinion, what can we do better to ensure the voice of the child is heard in all we do? What can we do better? I think that's an interesting question, Emily.
I think it's similar and this is my personal opinion, I think that if we had a system similar to the UK system of CAFCAS, or the availability of assessors in almost every case that they would be warranted in. And maybe as a matter of course, I mean, that's the ideal. I don't know whether, as you say, Stephanie, very rightly, that it's about costs and it's about being able to put that structure in place. And that's a massive undertaking for the court service to do. But I think to do better to hear in the voice of the child, the guidance leadsons and the assessors and the psychologists that we use invariably are all excellent, but it's just difficult to get them. It's difficult to pay for them. And it's difficult for them to have the time to be able to spend on these cases and provide us with reports quickly as and when they're needed. So if you're asking what my opinion is to better hear the voice of the child, it's to put in a specific structured service that all court users involved in issues that affect the welfare of their children or require the voice of the child to be heard can access very easily and cheaply. I suppose the CAFCAS system in the UK is a government run, so the government undertake the costs of all of that, and that's there has to be the where we're looking to, that has to be the ideal, that's available to every party who's involved in issues regarding the child. And that would be my opinion as to how's the best way to hear the voice of the child. I don't know if you have any views on that, Stephanie.
I wonder, in terms of CAFCAS, we're kind of steering off a little bit now. I know we did a case last year in which the parties had lived in England and CAFCAS had been involved. And I know that both parties thought that CAFCAS had become quite formulaic in their approach to after years and years and years of the system being there. But having said that, it certainly would be better than what we have, which is nothing.
Yeah, I think that's the problem. And the issue is the massive delay it is because, you know, if we were getting reports ordered at the beginning of proceedings, and then there might not be so much delay, but invariably it's usually when we get to a hearing and matters are so intractable that you can see no other way of solving them. So you could have been in and out of court 3 or 4 times before a report's been ordered, and then reports can take months then, you know. I mean, I know COVID's made that worse, but it's
I thought, remember we were talking to Anne Staunton at the beginning before we came online to do this, and I thought she was very interested in talking about what happens in school. And you know, there is definitely a role, because what happens when the relationships break down, it impacts on the teachers, because the difficulties, the children bring their own difficulties into school, and that impacts on the manner in which the teachers can teach. And I suppose there's a role there, a more holistic role for education, early education, and then primary and secondary school education, certainly for maybe the provision of psychology services, which there are in some schools. And it doesn't seem to me to be, I don't know, sometimes I hear of schools that have resident psychologists, and I'm astonished. I wouldn't have thought they would, but they do. Maybe there's a role there to play, but
so certainly like a guidance counsellor role, I suppose, something like that as well, that wouldn't necessarily just for career advice and things in secondary school, but you know, that kind of person that they can, it's almost like a family support worker that they could go to, do you know? But maybe obviously with the qualifications to assist through issues. And the GP, maybe the one. Sometimes I find with parents, when they're in a very difficult dispute, they'll say to me, I just don't know where to go. And I often think, well, the GP should be a good starting point, because everybody knows who their GP is and where their GP is. And, you know, it should be that the GP should be the person who's able to feed off into something. And we just don't have that in Ireland at the moment. So, I'll just have a look at some of the other questions now. Another one. If an assessor did not include one parent in the report and did not communicate with her or include her views in the final report, what can she do? This is based on a client's experience that came out of a domestic violence relationship. I think in that respect, obviously the report's there, you kind of stuck with it in that respect. However, the report isn't determinative of the view of the court in every respect. So the judge is the person that really should be making that decision. So I suppose that maybe it's up to legal representatives to put that to the assessor in their evidence, and to, I suppose, pick holes in it, and to maybe cast doubt on the evidence that the assessor's doing if they haven't done their job properly. But I suppose it's a risk, just as it's a risk in every profession, that you might go and have someone that doesn't do what they're supposed to do properly. But the ultimate decision maker is the judge. So you would, although the report is there and it would be given great weight by the court, it is only one of the pieces of evidence that's before the judge. So, you know, I suppose it's up to you as your solicitor, for that person to challenge the report and to show the court that it's maybe not as reliable as it could have been, you know.
Yes, and that's what we do. I mean, that's what, well, I must say, I'd say probably out of every 10 reports that come before the court, I'd say 7 of them. Maybe is that too many, Emily? 6 anyway, definitely 6, maybe 7. You've got, sorry, there'll be agreement reached on the basis of the report. People will reach, even the process itself helps people to reach agreement. But it's those last few that there's not. Now, I must say, it's a long time since I've had a ding-dong of a fight in relation to what the contents of the report are, and a real dispute in relation to it. I have one coming up on Monday, and we've had to, in those circumstances, I should say, you can call the assessor to come to court to give evidence, whether you're for the person who's happy with the contents of the report or unhappy. So I think that's very important to say, that if people are unhappy with the contents of a report, they can challenge it in court, and they can give their solicitor or council instructions as to the issues
Yeah.
that they're unhappy with, and then they can be challenged and put to the court. And most certainly, maybe not so much in the district court, but categorically the further up the food chain you go in terms of these disputes, to the circuit court and onto the high, that very definitely happens, and people are assessors are cross-examined very, very robustly. So that can be done, you know. Somebody wants to know, if a child has an advocate, could they provide support and a voice for the young person? And somebody else wants to know, what is CAFCAS, which is a fair question, it has to be said.
It's the Children and Families Advisory Service, is CAFCAS. So what it is it's and again, not to go down that rabbit hole, it's a service that's provided in all family law proceedings in the UK, that they get involved in the family when an application is made, and they undertake some mediation with the family prior to the matter coming before the court. And then if the matter still has to come before the court, they become involved in the family the whole way, with the family the whole way through, to prepare assessments and reports in relation to access or custody arrangements, and to report to the court if those arrangements can't be agreed. So they take a really similar role to the Section 32 assessors here in Ireland, but they become involved much earlier, and they also can supervise access or look at access as well. So they kind of do a bit of everything. But it's the Children and Family Advisory Service of the UK. Okay.
And then the last question, an important one, is it the court or the judge who orders the report on the voice of the child, or the solicitors acting in the case that must apply a request for it to be carried out?
Either or. So a judge can direct a report of its own motion if they feel it's necessary, or either one of the parties can apply either on consent by agreeing with each other, or can ask the judge to make a report, to direct a report if they think it's necessary to determine the matter, or there's issues in dispute. One more point that Stephanie made that I think is really, really important, and I just want to reiterate it, that the process of the report itself is often where the mediation and the agreement lies. And I think that's so true. As Stephanie said, maybe 6 or 7 reports we get end in an agreement at the end, but it's the process of that. I was talking to, as Stephanie mentioned, to Anne prior to the webinar commencing, that I was speaking to a gardener Leeton yesterday who was preparing a Section 32 report for me on the issue of relocation. And he said to me, Mum and Dad are really at loggerheads, he said, but the child got in trouble at school, and the teacher then had to contact Mum, but the child was with Dad at Access. And she rang the gardener Leeton and said, listen, I don't know what to do about this. The child's away. I don't know how to deal with this. And he said, ring Dad and tell him what's gone on, and ask, and speak about what you want to do with it. And she did. And it was a massive stepping stone. Like, Dad was really appreciative that she included him, that if the school had rang her, that she'd shared that with him, because the school could ring either of them, and that they could both address the issue with the child together. So that wouldn't have happened if that assessment hadn't been taking place, and that assessor hadn't been involved with them and had looked at the bigger picture with both parents. So I just think that the process is often equally as important as the outcome. Not in all cases, but I think it definitely helps. So, but anyway, I'm just going to go on now just with the rest of the slides, and just before I pass over to Stephanie, just to answer the question which is in the learning outcomes about the voice of the child versus the best interest of the child. And we have kind of touched on this in our discussions anyway, but we've talked so much about how important it is to hear the voice of the child, and it is important. And not only is it important, we're statutory obliged, and the Constitution says we have to, but it's there, all there for a reason. However, accepting and acknowledging how important it is for a child to express their views and make them active participants in the decision-making process, it gives them a voice in the most important matters affecting the child's upbringing, and allows them to participate in decision-making in a manner that reflects their age and maturity. But as we've already talked about, that right does not mean that the child's view will be determinative of the matter. And indeed, the research is very clear that most children do not want their views to be the final say in proceedings. It has also been litigated that attaching too much weight to the views of a child may in fact run contrary to the European Convention of Human Rights. And the leading case in this matter, see in Finland, a Finnish court awarded custody of 2 children to their father following the passing of their mother. Upon appeal to the Finnish Supreme Court, they overturned that decision and granted custody to the mother's female partner based on the views clearly expressed by the children. And the European Court of Human Rights found that the Supreme Court had violated the father's right to respect for his private and family life by giving absolute weight to the views of the children without properly considering the father's position and interests. And I suppose the point I'm making is that, of course, what any child says must be listened to and must be taken seriously. And as this quote says, but the professionals involved must be very careful not to prejudge the issue. And it's really important that although we listen to the voice of the child, hearing the voice of the child is in the context of what's in their best interest and in relation to the overall issues affecting the child in any said proceedings. So that's all I really have to say today in relation to the private law proceedings. It is a bit of a minefield and there's a lot of work still to be done, but things are improving and we're getting there. But I'll hand you over to Stephanie now, and she can talk to you about the public law proceedings.
Okay. All right. Just before I start, there was one more question I just want to finish. Somebody asks, is there a similar organisation to CAFCAS in Ireland? It seems they only deal with the UK. No, there isn't a similar organisation. We wish there was, but there isn't. And I actually don't think there are any plans to have one either. But for the moment, that's really what we're saying we would like. Earlier on, somebody raised the question, how much does a report cost? Well, and that's a very interesting question. So I had a look at what the Legal Aid Board will pay, and they will pay roughly about €334 per person, provided both parties are legally aided. So I have one at the moment where there are 5 people, mum and dad, and 3 children. And the Legal Aid Board will pay €1,670 excluding VAT if both parties are legally aided, but will only pay half of that if only one of the parties is legally aided. And that cost includes all of the meetings, to include a consultation with the solicitor or the barrister on the day of the hearing. So if it's necessary beforehand for there to be a consultation with the assessor, that's included in the cost. They will pay separately for court attendance. So a half day is €500 and a full day is €800. It'd be in a bad way indeed if a case was going to take a full day, although it has been known to happen. In general, when Section 32 was introduced in the 2015 Act, it was what the legislation wanted, what the government wanted is they had the right idea at heart. They wanted these reports to be done quickly and inexpensively, and they wanted them to be available, in every district court in the country. And initially, when we got our legal aid certificates, the fee for the report was €335. But nobody would do it for that, because for such a long time prior to the coming into operation of the 2015 Act, astronomical sums had been paid for Section 32s, Section 47s in the Circuit Court, which, as Emily has already said, is the forerunner, if you like. The very first, the daddy of them all, was Section 47 of the 1995 Act, and then Section 32 of the 2015 Act came in. So we've been dealing with the 1995 Act for some time. And I heard relatively recently of a report where the fees for the assessor were €10,000. Now that to me is just mad altogether. It was a difficult dispute, my understanding is, but there were still only 2 children. And some of the assessors, depending on their qualifications, would be very, very, very expensive indeed. And then no more than the question I raised with Emily earlier about CAFCAS. And I'm sure there are people who wouldn't like me to say this really, but some of the assessors would be fairly well known for coming down on one side or another. And that's a disaster as well, because if you're unlucky enough to be the other sex in the arrangement where an assessor is known for coming down on dad's side or known for coming down on mum's side, that's a pointless exercise altogether. So people will fight very hard, sometimes lawyers on behalf of families, to have maybe a person that they would perceive to be neutral. I do think there's a good deal more neutrality in the district court in the Section 32 reports, because hopefully there'll be more and more people doing them. Now, there's actually not that many people doing them. There's only, say, I operate in Louth, and obviously that encompasses Drogheda and Dundalk and also parts of Monaghan, really. And there really are only 2 or 3. There's not that many at all. So there's definitely room for more. And I think in terms of what we're generally discussing about having the voice of the child represented, if it's to become something that's more routine, that the voice of the child would be listened to and represented to the court per a report, then we should have more and more people doing these so that they become more commonplace, and as they become more commonplace, then they become less expensive. But there is no doubt about it that the cost of them can be fairly considerable. And outside outside the remit of an awful lot of parents. I mean, most parents I know. I mean, the 10,000 euros was a lot, but I would routinely hear of assessments costing 4, 5 and 6 grand, and I don't know who has the money for that. It does come down at a certain level. You know, really, well, I suppose if people are in a relationship for a period of time, be it long or even short, you'd like to hope and to think that the vast majority of people respect one another enough to be able to parent their children and to do the right thing. It's only when things go wrong, obviously, that you have these disputes in court and that you then have to have the reports. I suppose we're lucky, really, because prior to 1995, nobody listened to what the child, it was anathema to even consider that you'd be talking to anyone under the age of 18 about what they wanted. So this is good. It's good that we have developed this far.
Sorry, Stephanie, I was going to, just a couple of inputs on the Q&A. Someone said that most Section 32 seem to average about €3,000. And I think, to me, that's kind of more 3 to 4 for Section 47s. 32 seem to be a bit cheaper. And especially, what a lot of assessors will do is if they're just doing the voice of the child, so 32 1B, then it will be cheaper again, because they're not really asked for their professional views. It's more just their professional expertise in obtaining the views of the child. And so that could be a little bit cheaper. But the reality is that they can charge whatever the assessor wants to charge you. And I think I've always, I think is a really good idea if you had a panel and a sort of, you know, like consultants have a private caseload and a, you know, medical consultants private caseload and a public caseload. And maybe if there's a panel that would do it for a certain fee from a public, you know, panel that we could just pick from and do that, that might be easier. And just one other matter is that in relation to obviously all these changes that we want to happen with the family law and the prospective family law court bill, one family is having a webinar on building a family law system for children in case anyone would like to attend, and we can pass over the hyperlink for that if anyone wants it. So.
Okay, just going back again further, there was a question much earlier about the dissemination of the report, and that is a very good question again, because despite the fact that the legislation specifies copies were to be made available, that practice came to an end a number of years ago, because unfortunately, like in all of these things, a small number of people ruin it for everybody else. And some of the reports were disseminated on social media, and indeed there was one a situation in Dublin whereby copies of the report were put up on the lampposts and pasted onto the lampposts, so it had to stop. And now the reports are not in fact given to the participants, so whoever it was raised the question of how can you have a situation whereby these most important reports are drawn up with reference to the person about whom the reports are being drawn up, and yet they don't get to see a copy of them. And that's correct, but there's nothing we can do about that. Now, I had a case recently with Judge Daly, Colin Daly, and what he said was that a copy of the recommendations of the report could be copied out to the client. And I have to say that was news to me, but fair enough. And that definitely, I want to contrast the difference there between private law and public law, because we are very definitely directed not to release the reports in public law cases. So well done, Emily. I think that was very interesting and very good. So dealing now with the public law cases, and as Emily said, public law cases relate to issues concerning the child, the state and the family. And the act that governs the care of children, the welfare of children in that regard, and the duties of Tusla, who are the Child and Family Agency, that is the Childcare Act 1991. And that's quite a young act, actually, when you compare it to the previous act that dealt with these matters, which dated from 18-something. It was quite an old act, but we now have, there is a more up-to-date bill before the Dáil, which unfortunately ceased at the end of the last Dáil, but hopefully we'll come back together again. So in terms of taking children into care, that happens when the welfare of a child could be neglected, is likely to be neglected, or irreparably damaged in some way. Then the state would have to stand in, or indeed where the child's welfare is being avoidably neglected or impaired, then the state has to stand in, and the state does so by procuring orders under the Childcare Act 1991. And those orders range from taking a child into the full care of the state until they're 18 years of age, right the way down to a thing called a supervision order, which means the children remain at home with mum and dad or with the family as agreed by Tusla, and Tusla can drop in on them to see how things are going and support them in other ways. So Tusla being the state agency, it staffs social workers and team leaders and things like that, and every child will be appointed to social worker, at least that's the theory. It doesn't always work out like that in practice. But in any event, if necessary, and if the state has to bring an application to take a child into some form of care, then the state is represented by the Child and Family Agency. The social worker is the voice of the state in those circumstances. He or she gets into the witness box to give evidence as to why this is necessary. The parents or parent, maybe sometimes depending, will be there, and often they are represented primarily by the Legal Aid Board, but not always. There are some people who are represented privately, and sometimes they're not represented. Sometimes maybe they've gone abroad, or they're not around, or they're dead, or whatever. And if that's the case, then obviously they wouldn't be represented at that time. And the Child and Family Agency must prove to the court that the threshold for keeping the children or taking the children into care is in place, that it is not disproportionate to do so, and that it is required because of the circumstances of the child. And the social worker or the Child and Family Agency can seek to bring children into care on an emergency care order basis, in which case they would ask the guards to come and take children in a hurry, usually in the most terrible of circumstances or awful circumstances. Supervision orders, as we've spoken about already. And then in circumstances where care orders have been sought by the court, sometimes it's not possible to have the care order dealt with immediately as soon as the child is taken into care. There has to be maybe some work done, there have to be reports done, maybe some therapies are required, maybe some physical issues required to be dealt with, and the Child and Family Agency will want to complete them before they come to court. And obviously, for those of us who have acted on behalf of parents down over the years, we see it then from the other side. It's rare indeed that a parent will consent. It does happen from time to time that a parent consents to a child or children be taken into care. I apologize. Primarily, it happens when people know they just can't do what the child needs, when the child's either needs are too great, or where maybe as a result of addiction, or they're just simply not in a position to do it. Very occasional, but it's a very difficult situation, and it's not one that arises very often. More often than not, the parents will instruct us to oppose the application. And so when the social worker gets into the witness box and says, these are the reasons, then we would obviously have instructions as to why those orders should not be made. If the Child and Family Agency, if it looks like children are going to remain in care, it's a kind of a long-term thing, then an interim care order can be granted for a 28-day period only, and that can be extended on, and sometimes unfortunately it gets extended for quite a while. You could be extended for a period of a year, or maybe a lot longer than that, before there's a hearing. One of the difficulties we have with hearings is that hearings in childcare cases, for the most part, if you get to a stage where the Child and Family Agency want to retain children in care because they feel the parents can't take care of them, and if that application is contested, you're never really under a 2 or 3 day hearing. And a shortage of judges, which there are at the moment, means that it takes time to schedule a judge to come down. So, for example, at the moment, we're looking for judges in a number of cases, or the Child and Family Agency are, but even as parents with the children, we know this matter has to be resolved. It's not good for the children if it's not, or for the parents indeed either. And we're looking for dates to be given, and I don't think there's any dates available before October, November of this year. And we'll be looking. Now, that is partly to do with COVID, but in general terms, it takes a while to get a hearing date. So you may ask, how is the voice of the child heard then in the context of childcare disputes? Well, we have provision in Irish law for the appointment on behalf of a child of what is referred to as a guardian ad litem. And Jeffrey Shannon, who was the rapporteur for children a number of years, well, actually up to last year, I think, has written extensively about this in the book. And he describes a guardian ad litem as an independent representative appointed by the court to represent the child's personal and legal interest in proceedings under the Act. He says, the Children Act 1997 has further extended the range of proceedings in which the guardian could act by allowing such appointment in certain private law proceedings, but those proceedings, as Emily has already said, those sections of the Act haven't been commenced yet. So in Ireland, a guardian ad litem will only act in a public law case, in other words, in a childcare case. And the person who can seek to have a guardian ad litem appointed is either the court of its own motion, so a judge, and for the most part, the judges will say, I get a guardian ad litem into that, and they'll appoint a guardian ad litem, and they may say to the practitioners, the protagonists in the case, who's available or who would be appropriate in this case. Some judges are quite proprietorial about guardians ad litem, and they want particular guardian to be appointed, and they'll say, bring in so-and-so, bring in so-and-so. And also the parents can ask for a guardian to be appointed, and we have done that ourselves. So it was in the public law sphere in section 26 of the Childcare Act that first allowed the court to appoint a guardian ad litem to represent the child's legal and personal interests before the court and to act on a child's behalf. In order for the court to do it, the court must be satisfied that to appoint a guardian ad litem, it's necessary in the interests of the child and consistent with the requirements of justice. And in all situations where it is contemplated that a guardian ad litem might be appointed, the court, section 24 of the 1991 Act, promotes the child's welfare as being the first and paramount consideration in all cases, although the court is obviously directed to have due regard to the rights and duties of the parents. The court should also, as far as it is practical to do so, have regard to whether the child has a wish in this regard. But, you know, obviously, the younger the child, the less likely the children are to even understand the concept. But I must say, I find on a personal note that when we're acting in childcare cases and where a guardian ad litem is appointed and they go out to see the children, most of them are very highly qualified, and indeed they will have been former social workers or psychologists or sometimes psychiatrists, sometimes a combination of all. Maybe sometimes they've taught as well, they've been teachers, and they'll have huge experience and be obviously very good at, obviously it's something they want to do. Sometimes former social workers, some of the best ones indeed are former social workers, and they go out and they are appointed guardians ad litem themselves, and they're very, very good with dealing with the children and explaining to them what their role is and what they can do. But obviously, sometimes you will have a child who's too young to understand that concept. Babies, or anybody, any child really up to the age of 4 or 5 isn't going to obviously understand. And in those circumstances, the guardian ad litem must bring their own experience to bear in deciding what the issues are and what information needs to be put before the court, and in bringing before the court what they perceive to be the wishes, what's in the best interest of the child. And that's the role of the guardian ad litem. So I suppose the older the child, maybe the easier it is, you might say, because then a child is able to say, well, I want this, or I want that, or I want the other. And it is extraordinary reading the reports. It never ceases to amaze me, really, when I read a report of a child 8, 9 years of age who are so articulate and so amazingly able to cope with the circumstances, the usually adverse circumstances they find themselves in, and how well able they are to say to the guardian ad litem what they want, and to say it in the most gentle and compassionate of terms. It just goes to show you, really, we're all lovely as children, and things deteriorate a bit as we get older. But I had a report there recently where the 8-year-old, the insight demonstrated by the 8-year-old mum has mental health difficulties and addiction difficulties, and the 8-year-old said through the guardian ad litem in the report, which was made available to the court, you know, of course, I'll always love mum. I really love to see mum, and I love spending time with her. But in the house of the foster parents, it's warm and it's dry and there's food, and I know I can do better so that I'll be able to be a better son for mum in years to come. And I thought that insight was, maybe it's not insight, but that ability to kind of balance the two things was remarkable. And part of that is obviously down to the child and the amazing nature of children, really, but also part of it down to the guardian ad litem and his, in that instance, ability to extract that kind of information and those disclosures by the child. So on a practical level, what happens is when an application is made to take children into care, every month, as I said, the interim care order is extended if it has to be extended. A social worker must provide a report confirming that the threshold for retaining the children in care has been reached, and that it is proportionate to retain the children in care, because if it's disproportionate, then it shouldn't be happening. So they'll get into the witness box and they will have sworn a report which will have been sent out to us to read. Sadly, usually only the day before. We rarely have very much time because they're busy and they don't have enough resources. But also the guardian ad litem then will have gone out to visit the child in the interim period and will have done a report and will have provided the report usually a bit before the day before the court. And we're then able to take our client, being usually the parents' instructions in relation to it, and tell them what's happening. So the guardian ad litem not only provides the wishes and the views of the child, but also what's in the best interest of the child, but it's also a conduit for communication with the parent. It's sometimes, a lot of the time, in childcare cases, the parents aren't really able to communicate with the Child and Family Agency. They see them as the enemy, and they see them as the person who, or the people who've taken their children away. So often communication with them is limited or is not as good as it might be. And sometimes the guardian ad litem can provide a good role in that regard. Sometimes the guardian ad litem has to go toe-to-toe with the Child and Family Agency if, for example, therapies of some sort are required, or perhaps, I'm trying to think, I know we had one last year where it was recommended that the child have a very specialised form of physiotherapy that was very expensive. Someone was going to have to come to from England to give it, and it was obviously going to cost a lot, and the Child and Family Agency were dragging their heels, in fairness, not because they wanted it, but because of the cost of it, and it hadn't been approved. And the Child and Family, or the guardian ad litem, really went to bat for the child, and the therapy was procured because of the insistence of the guardian ad litem. So they go into court as well, and they advocate on behalf of the child, because there's no doubt children can fall through the cracks in relation to it. So they'll meet with the child, they'll speak with the child, they'll draw up the reports, they'll communicate with the schools, with the doctors, with the hospitals, if the hospitals were involved, with other services, the therapists and things like that, and they advocate for those in front of the judge. Usually the role of the guardian ad litem will come to an end when the care order is granted, but oftentimes they will be reappointed for the review stages after the care order has been made. And sometimes the judge will permit the guardian ad litem to remain on for a certain period of time in order to ensure that the child has confidence in their life after care. So I suppose people might ask, how do guardians ad litem, how are they appointed? What are the roles and qualifications? And in May 2009, the Children Acts Advisory Board published guidelines on these issues, and that board sets out a number of recommendations, and also a number of recommendations for reform in the area. Obviously, just in general, guardians ad litem have to be fully vetted by the Gardaí. They have standards of training and the manner in which they're to conduct themselves throughout the process, from preliminary inquiry stage to post-case care. However, it has to be said, and again, Jeffrey Shannon says it, that if these guidelines are to be truly effective and to work properly, then they have to be put on a statutory basis, and that's not happening at the moment. There are a series of High Court cases referring to the issues surrounding the appointment of a guardian ad litem, and in this regard, I should say, most guardians ad litem nowadays are represented by a solicitor, and dependent on the complexity of the case, they would be also represented maybe by counsel. And the reason for that is if you've got a fully contested adversarial hearing, then the guardian ad litem would feel that while they're expert in their field, they're not necessarily expert at the court proceedings, and so they will require to be represented. And there was a series of High Court cases really around what is the definition of a guardian ad litem, and what is their role, or are they a party to the proceedings? Are they an expert witness? And that question hasn't properly been answered yet, which is why we're all waiting and hoping for the legislation, because really people take very different views in relation to it. So it remains to be seen, but nonetheless, that is primarily why I think, but that the nature of that issue is at the root of why a guardian ad litem has a solicitor and sometimes counsel. So
definitely to interrupt
yes.
you, but we have just a question now, which is just about what you're speaking about. And someone's asked, do the guardian ad litems have training in ascertaining the wishes, voice of children with significant additional needs, e.g. moderate to severe intellectual disability? So it's about what you were talking about, the qualifications. And
Yeah.
yeah.
There isn't a guardian ad litem training school, do you know? There's no degree you can go to. Most of the guardians ad litem are former social workers, psychologists, psychotherapists. As I said, there's a few psychiatrists. An awful lot of social workers leave primarily because they get so exhausted, I'd say, really, in child protection.
Burnt out,
yeah. Yeah, and really they get burnt out, and they go into this then because what a lot of them went into social work to do was to deal with children and help children, and they find they're so bound up with all of the paperwork, etc. So they do it. And there would be some that would have very significant experience of dealing with people with special needs. So it's horses for courses, really. A lot of the guardians nowadays band together, like there's a group called Tigala, Tigala, and I think there's a band of 7 or 8 in there. And I think if you were looking for somebody with very specific abilities or maybe not qualifications, but skills in that area, you should go to Tigala saying, have you got someone, or can you recommend someone? You know, and no guardian ad litem, in my view, well, I'm not saying they're all amazing people or anything, but what I am saying is I think they're very nobody would take on to do something that they're not fit to do. So that if it was something that was required specialist intervention, I have no doubt any of the guardians that I know would say, no, I am not doing that, but I'll recommend someone else to you.
And it's just as you were saying, Stephanie, I think most guardians come from a background of either social care or working with children with disabilities or working in whatever other kind of social care field. So they usually would have specific experience in some areres like that. You know, they don't start at 21 as a guardian ad litem. It's usually on the back of so a lot of them would have that kind of experience, I suppose, where they're used to dealing with children with certain needs.
So also the new act, when it comes, the Childcare Amendment Bill 20, I think it finished at 2019 when the last Dáil was dissolved. Like, it will bring huge clarity to the role of guardian ad litem. And for example, and this is just an example of what's not obviously in legislation yet, but a person will not be eligible for appointment by the minister as a guardian ad litem or eligible for inclusion on the panel of guardians ad litem established by the minister unless A, they have a relevant qualification in social work, social care, psychology or psychiatry, and B, have been the subject of vetting, obviously. And it goes on to say that if a person holds the relevant qualification, they must have 5 years at least postgraduate experience in child welfare and child protection. And the same with psychology and psychiatry, the same thing. So obviously, if when the act is enacted, and it is going to happen, it will happen. And when that does happen, I think we'll have much greater clarity. But again, for what it's worth, and just speaking anecdotally and from experience, there's of all the guardians ad litem, I've sort of actively worked with maybe 15 over the course of my career, and there's really only 1 or 2 that I wouldn't be delighted to see coming. Briefly then, what are the functions? What are the duties of the guardian ad litem? Well, first of all, to meet the child, the subject of the proceedings, to identify the nature of the proceedings and the parties involved, to conduct a comprehensive inquiry into the child's circumstances where he or she is living, and to provide independent recommendations to the court, to understand the judicial, legal, social, political and governmental systems affecting the child, to try to achieve the most appropriate outcome for the child, to consult with the child's family, kind of funny to see that so far down, but nonetheless, assess the impact of the proceedings on the child, and if necessary, act promptly to help protect the child from further stress or distress, to decide on the necessity or otherwise of expert evidence, bearing in mind the negative implications of delay, to assess the level, timing and manner of state intervention in the life of the child, and finally, to provide a written report to the court. Now, that is what they are directed to do or advised to do under the Children Acts Advisory Board's guidance rules at present. So hopefully all of that will go into the Act. But that in effect is what happens at present. So we then come to the guardian ad litem reports. And Emily was speaking earlier on about the reports in private law cases. Obviously, I'll reiterate what I said, those are not disseminated to the parties. So what we tend to do is read them to the parents, not parties, parents. We read the contents of the report to the parents on the day of the hearing. Not ideal. If they arrive in a day or 2 beforehand, you can ring the parents and go through them with them. But again, it's not ideal. But you cannot give a copy to the parent involved, and so the parent, you're relying on them giving you their instructions in relation to the contents of the guardian ad litem report when they hear it. The reports are covered, as indeed are all family law cases. They are covered by the thing called the in-camera rule. And the in-camera rule is a Latin phrase meaning in chambers, which refers to the judge's chambers, but what it really means is private. It's private. And you cannot disclose things that happen in family law cases to outsiders, because the purpose of the in-camera rule is to protect the privacy of the participants, including the children. It also is to protect the identity of the participants and any children to whom family law or childcare proceedings relate. So where the in-camera rule is applied, you cannot give anyone copies of court documents unless the in-camera rule is lifted by the court, allowing you to do so. And sometimes that does happen if, where, for example, an assessor is coming in or a guardian ad litem is coming in, the rule will have to be lifted to give the guardian ad litem copies of the child, of the social work reports, for example, or maybe there's a doctor's report or something like that. And if it's in the context of the proceedings, you can apply to lift the in-camera rule in that regard. There's a lot of debate and discussion about the in-camera rule. Should it be there? Shouldn't it be there? But I honestly think that if people's private family law matters were subject to reporting in the papers, or if anybody could just walk in, it would be terrible. And in fact, it would simply be unworkable. So sometimes people will complain and will say, oh, behind closed doors, who knows what's happening? But really and truly, I certainly can vouch for the fact that all of the judges and participants in these proceedings take them very much seriously, and very much the in-camera rule is applied across the board, so everybody is treated in the same way. If a third party requests court documents or information in relation to proceedings covered by the in-camera rule, you can't give them those unless, again, the in-camera rule has been lifted, or unless the court directs that is the case. As an aside, I will say the childcare law reporting project that was run by that journalist, what was her name? I'm going to forget her name, from the Irish Times. She ran it there for a number of years. I'm not sure, she's still not running it. And that was excellent because it enables people to understand and to see and to read about what's happening in these cases, and to build up a body of not experience, what's the word? A body of work, I suppose, setting out what's happening in childcare cases, and indeed in private law cases as well. So it is possible to have information about family law proceedings and childcare proceedings with the identities of the parties involved.
It's Carol Coulter, Stephanie. That's why my slides went mad, because I was trying to unmute myself. But also one of the participants did mention it also. Thank you.
Yes, and Carol is excellent and does excellent work. I hope she's still doing it. And really, her body of work and the work that she has done is available for everybody. The reports come out every year and they make fascinating reading, truly. And they're very useful for us as well, because the one thing she will always do is she'll say what part of the country she's in. And even though the rules and the law apply across the board, nonetheless, there are different approaches by different judges and in different parts of the country. Indeed, there are different levels of childcare proceedings in different parts of the country. Oddly enough, some places have higher numbers than others. And it's always interesting to see what happens in other parts of the country, despite the uniformity of the law and the rules.
Yeah, just one question there from a participant. Does the in-camera rule apply to the recommendations from the judge? So I presume that's the order that the judge is making?
Well, yes, it does. It absolutely does. And that's where the crack starts, really, because of course nobody is going to come out of a hotly contested case and go home and say to, their friend or their mother or their sister, I can't tell you. And that's the unfortunate thing. There's nothing we can do about that. So it's our job to explain to people the in-camera rule covers this, and you can't be disseminating it. But really, I suppose everybody knows people will say to their nearest and dearest what happens. What you're hoping for is that they won't go any further than that. And of course, there are people that do that and put stuff up on Facebook and all kinds of things. And there's not, I was going to say there's not a thing you can do. There is actually, because they'll be held in contempt for the breach of it. And not infrequently, I would find myself in court saying, I really want a direction of the court very clearly that there's that the person should be held in contempt on the next occasion. I've never actually seen it happen, but I think it's very important that it be taken seriously.
Perfect, thanks.
So again, I suppose the last thing I would say is there is a lot of focus, I think Emily had dealt with this already, a lot of focus on the voice of the child and empowering and including children in proceedings that affect them. But that has to be balanced against what is in the long-term interests of the child and the welfare of the child, and it must be done in whatever way it's done is to protect them at all costs, really, as best possible, if it's possible, and I mean if, from acrimonious and potentially emotionally damaging proceedings. I do always think, really, my heart goes out to children who are taken into care, you know, because in the end, all any of us probably ever really want is stability, and to live in a house, in a place rather, with our parent or parents, and, you know, to just live a normal life. And I think when children are taken into care, it's never lightly, it's never done for little reasons, it's always for big reasons, and it's very difficult. So I suppose the one thing I would say is the appointment of a guardian ad litem to children in that regard. It's good that they have an independent person that they can go to and that they can speak to about what it is they want. They may not always, as Emily had the very good example of the child who didn't want to go to school anymore, they may not always get what they want. But the sad thing sometimes, I think, when I read the reports, is it's amazing how clued in children are in these circumstances to the very serious issues that affect them. And so they rarely come looking for something flippant. It'll always be serious. I mean, they might occasionally, you know, say, I'd like a pair of roller skates or whatever, but in general, what they're thinking of is home and the family and the general family and school. You know, sometimes they'll say in the reports, I just want to be able to go to school and to learn, because they know themselves that's about stability.
Yeah.
You know,
we've just got a couple of questions, Stephanie, a comment, Stephanie, sorry, in the Q&A. Is that in the hospital, we often request a copy of an order for the child's record, whether it be childcare orders or private orders in relation to guardianship, etc. Is this wrong?
That's an interesting one. I don't think you should be doing that myself, but you know, hospitals are big places with lots of lovely, expensive lawyers, and not in any way, it's a very good question. I don't think that would be happening. Now, obviously, if there's a childcare order, obviously, if an order was made, you know, that a child, or that if a child is in care, then who'll be going to the hospital looking for the treatment? I suppose it'll be the social worker, it'll be the foster parent at the behest, and I suppose that has to be answered. Not sure, but certainly ask, and I don't think I'd be too happy that clients of mine were giving out copy orders. What about you, Emily?
No, I think that the only way that really you could give an order is if you had the in-camera rule lifted by the court for that specific purpose, because I know that if you're in breach of the in-camera rule, not only if you give the information, but also if you receive the information, you know, and there is case law supporting that, but I think you would have to ask for permission of the court to be able to provide that document.
I suppose there are also circumstances, though. I know, I'm just thinking of a situation whereby I had a non-marital case and I was acting for mum, and there was an accident at home. The child fell off a wall and dad brought him in and said that he was the custodial parent when he wasn't. And I suppose then the hospital would rightly say, how do we know? I suspect it's something that the hospitals will have thought about very carefully and will have received legal advice about. And it's probably something you should be asking management about, really.
And actually that person's come back and said in relation to the hospital, it's so the hospital is aware of who can consent to treatment, etc. And listen, you know, it seems evidently sensible. It's just, it's a difficult rule to kind of get around. If someone then made an issue of it into the future, you know, there could be an issue there. But listen, you can always ask. You might not get, you know, but
if you've the consent of the parents, I suppose you can do anything, really, you know. So that I wonder, actually, that person is working in the hospital. Is that nowadays when people come in with children, do you have to say to them all the time, is this your child? Is this, like, are you a parent, or are you a grandparent, or are you a custodian? Maybe they do. Maybe that's the way it has to be nowadays. I don't know.
But even with children in care, if they require hospital treatment, even if there is an interim care order in place, the CFA will often go to the parent and look for their consent anyway.
That's correct. That's correct.
So they wouldn't go ahead even with an interim care order, which kind of gives them the authority as such. It doesn't remove the guardianship, the guardianship of the parents, though. So, you know, in my experience, the CFA would always go and seek the parents' permission. In any event, but I understand where the hospital would be coming from.
Me too.
Valid point. I think that's all the questions. Stephanie, you must have been very thorough.
I think I'm finished. In fact, I can't really see anything other than to say there are circumstances in which a guardian, I think I said this already, where guardians can be appointed in private cases, but that part of the Act hasn't been commenced yet. So are there any other questions? I kind of feel like I've raced through it at a great rate, not meaning to, but are there any other issues arising? No?
No, there's no other questions on. So yeah, but all the questions are really, really informative. Good. And it's great that we could, you know, that we could answer some of them, and I hope it's provided a bit of clarity. It's a bit of a minefield of an area, but
yeah. Thank you very much. Thank you.
Okay, to Stephanie and Emily, so many thanks for that this afternoon. And just to say to people, this is your second time this week repeating this webinar, but you just brought the voice of the child so close and opened it up in a very honest and humane way, and gave us not only the background in relation to the law, but certainly to the whole voice, you know, to what that voice might sound like, what they might think. And that's really, I think, will be very valuable to people on the webinar. And so many thanks for your time and for your patience and coming, even delivering this webinar. We know it's not always easy to create the time, and it's coming on a webinar with a lot of people can be daunting, but to have covered this subject during this week, it has just been great. The feedback from earlier was excellent, and we really and deeply appreciate your contribution on behalf of the Legal Aid Board, and thank you so much to both of you.